Hi, this is Barry Miller, attorney and president of the Closing Agent. I want to talk to you today about the term force majeure. Now, there's two types of force majeure. First is the common law force majeure, and we're really not to go into it, but just so you know, it is a common law theory, and to get out of a contract under force majeure, you have to have impossibility. And we're not going to really go into that because what we're going to be going over is force majeure in the FAR bar contract. So in your FAR bar contract, it is standard G, called force majeure. So first, we're going to follow along on the video here. You can see, let's go over the terms and just read it, because it's very important to go over it. And some parts of it can be confusing. So let's go through. It says force majeure, buyer or seller shall not be required to perform any obligation under this contract or be liable to each other for damages so long as performance or non-performance of the obligation or the availability of services, insurance, or required approvals essential, that's key, to closing is disrupted, delayed, caused or prevented by force majeure. And then they define it. It says force majeure means hurricanes, floods, extreme weather, earthquake, fire, or other acts of God. Unusual transportation delays, or wars, insurrection, or acts of terrorism, which, now this is key, by exercise of reasonable, diligent effort, the non-performing party is unable in whole or part to prevent or overcome. Then it states, all periods, including closing date, will be extended a reasonable time up to 7 days after the force majeure no longer prevents performance under the contract, provided, however, if such force majeure continues to prevent performance under the contract more than 30 days beyond the closing date, then either party may terminate this contract by delivering written notice to the other, and the deposit shall be refunded to the buyer, thereby releasing buyer and seller from all further obligations under this contract. All right, so let's go through and dissect this now. So first it says any obligation. So as we know, there's lots of obligations that are in here. The seller has to provide title. The buyer has to provide a loan approval. You have to provide certain notices. So you got to keep that in mind. Then it says required approvals essential to closing. Well, obviously, if the banks shut down, they won't. That would be essential. If, however, for example, let's say you are in your inspection period and your inspector says, I don't feel comfortable going in homes, I'm not going to be doing any more inspections for 30 days. Is that force majeure? No, because you have not taken reasonable efforts to get another inspector. There's plenty of inspectors out there. So in that case, it would not. Now, a frequent question that comes up is on loans. If the buyer has loan approval and the lender decides not to fund the loan or proceed on it, force majeure would not cover that, because that was their particular lender that they chose. So then they would still be obligated to close. This is very harsh, but unfortunately that's the way it is written here. And it says by exercising of reasonable diligent effort. So perhaps they could go to another lender. So this is a kind of a gray area. What I'd like to emphasize is on force majeure should not be used as a way to get out of a contract. What we need to do is look at it as a roadmap for resolution. And that's the big thing. Force majeure, a roadmap for resolution. So let's find out how we can do it. So first, we've got a standard addendum we'll be posting on the website to extend the periods that are in the contract for use that parties can do. So if they got to extend the closing date, the financing contingency, or the inspection period. This document is easy to use for any agent or any party. You can download it for free on our website. Use that. The big thing is keep communication open and try to cooperate with everyone. And our attorneys are here to assist our agents and our customers if they run into issues on this to try to help resolve these problems. So be very, very careful on these and try to look at it as not trying to get out of the contract, but trying to resolve it. And everyone's got to give some give and take and try to get this done. Now, one of the things that may happen is that a buyer needs to get into a property and they can't close due to lender issues. Maybe look at doing a pre-occupancy agreement, or the reverse. If something happens and the seller, they want to close, but the seller can't move out because of a moving company can't come and get them. How about a post-occupancy agreement? So there's always resolutions. One of the things we pride ourselves on is we're deal makers. So if you have an issue, let's talk it out and let's try to find a resolution. Let's get on that roadmap. Let's get to resolution. Let's get the deal done. So again, if you have any issues, contact us and we want to help, and we're always here to help. Thank you, be safe, and we will get through this.